My US citizen spouse died. I'm a green card holder. Can I apply for citizenship after 3 years, not 5 years? If you want to know the answer to this question, I'll see you on the other side. Hello everybody, and welcome back to our Immigration channel. This is a place where you get the most up-to-date immigration news, immigration information, and everything else that you need to make your immigration journey less stressful. My name is Jacob Sapochnick, and I'm an immigration attorney located in San Diego, California, and I have clients in all 50 states and all over the world. And in this video, we'll cover a very common question that I get often, specifically for my citizenship clients who are trying to apply for citizenship. There are cases where the US citizen spouse passed away, and the confusion is, can they still apply after 3 years, or they have to wait the 5 years? I'll explain that in a few seconds, but before that, if you're here for the first time, don't forget to subscribe to our channel, click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to show this video to more people just like you. Also give us a big like so YouTube can recommend this video to more people just like you. So let's talk about the Early Career STEM Research Initiative launched by the Biden administration recently. So how can you as an employer be part of this Career STEM Research Initiative? So first of all, you have to apply to find one of these agencies that are essentially designated by the State Department to be sponsors. So as you know, typically when you apply for citizenship, the general rule is that you have to wait 5 years after getting your green card to be eligible to apply for US citizenship. However, there is one exception. If you're still married to a US citizen and currently living together, residing in the same household, you could be eligible to apply only after 3 years. It's the only exception that allows you to apply for citizenship a little bit faster. And so typically, if you are in a relationship, if you are married to a citizen, and let's say you're separated, even that fact alone will not qualify you for the 3-year exception. You have to be living with your spouse, and you have to be legally married. But what happens when the spouse dies? And this is something that came up recently for one of my clients, and they were hoping that they could apply under the 3-year exception because they were living together, they were in a real marital relationship, and unfortunately the spouse passed away. And the client can prove all of that. They can prove that they live together, they have mortgage together, they have all the documents together until the date she passed away. However, sadly, under US immigration law, the exemption that allows somebody to apply for citizenship faster, as long as they're living together and married, is not applicable if the spouse passed away. And why the regulation doesn't specifically say that, what the Code of Federal Regulations does say is the following. A person is eligible for naturalization as a spouse of a United States citizen under Section 319A of the Act if, before or after the filing of the application, the marital union ceases to exist due to death or divorce, or the citizen spouse has expatriated. So this section of the regulations that controls who can apply for citizenship specifically does say that the spouse, if the spouse is deceased, the person does not qualify for the 3-year exception. Therefore, if you're applying for citizenship and your spouse passed away, even if you lived with that spouse before she passed away, even if you can prove that you were in a real marital union, because she passed away, you will have to wait the full 5 years. You can apply 90 days before the 5th year anniversary of your green card, but you won't be able to apply for the 3-year exception. In fact, the regulations go even further. If you submitted your N-400 form and you're pending, as you know right now, it's taken a long time for the N-400 to go through, over a year now. During this time, while you wait for your N-400 interview, your spouse passed away, and even at that time, you're not going to qualify for the exception. You're going to have to withdraw your application and wait for the 5 years. So even if at the time of filing, you were married, your spouse was still alive, and she passed away later on, because at the time of the interview, your spouse is now deceased, you're not going to qualify for the 3-year exception, which is pretty devastating because quite a few applicants are going through this process and only realizing at the end they're not going to be eligible for the exception. The point is that they're looking at anything that can happen to you before you take the oath. So for example, if you commit a crime, if you do something that makes you ineligible for citizenship, even if at the time of filing that thing didn't happen, but it happened during the time of waiting, anything that happens before the oath qualifies, which means that if the spouse passed away before the oath ceremony, you're not eligible and you have to wait for the full 5 years. I know it's frustrating, but at least now you know the truth. If you have any questions, let me know in the comments below. If I can be of any assistance in your immigration matter, text me right here, 619-483-4549. I'm here for you. Thanks for watching, and I'll see you in the next video.